Stop recording me. Stop recording me. There are other inconsistencies here. She claims that she was injured on the forearm. Like I said, she pointed to other different parts of her right arm, the tricep and bicep, and there was no visible signs of injury whatsoever. This is really, as far as I'm concerned, on top of that, this is frosting on the cake. We've got a child here who's 3 years old that had just been scorned essentially by his father, in the sense that, and I don't mean scorn, but told, I don't want this ice cream sandwich, and his feelings were hurt, and the victim testified to that. And yet a few minutes later, she's telling the police, mommy hit daddy in the face. There's no contrary evidence to support anything other than the fact that this assault did not occur. She also stated, please do not arrest me. I don't know why somebody would say, please do not arrest me, when they were the victim of an assault. So under no circumstance, honestly and truly, this is not a close call for me. There's no way the prosecutor proved her case beyond a reasonable doubt. You did a really good job, Ms. White.
Judge, I appreciate it.
And Ms. Holloway, you are going to be one remarkable lawyer. You've only been practicing how long?
Almost 5 years.
Well, you are going to be a really good lawyer. I love your demeanor, and I think you are going to be judge material. I find the defendant not guilty, and again, this is not really a close call. So
Judge, we appreciate
you're
it.
discharged,
Thank you,
and
Your Honor.
thank you.
Rule 6.419 AC, looking at a light most favorable to the prosecution without weighing the credibility of the witnesses, it is our position that the trier of fact cannot find that all of the essential elements of the offense of domestic violence have been proven beyond a reasonable doubt. Mr. Kennard is charged with domestic violence contrary to MCL 780.81 subsection 2. Number 1, pursuant to the criminal jury instructions, the people would have to prove that Mr. Kennard assaulted Miss Bonnie Stewart. Number 2, that Mr. Kennard is her spouse. Pursuant to the criminal jury instructions 17.2a, the essential elements would be, number 1, a battery is a forceful, violent, or offensive touching of a person or something closely connected with her. And number 2, the touching must have been intended by the defendant, and an assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit the battery or make the complainant reasonably fear an immediate battery. Your Honor, it is our position that the people have not met their burden. Factually speaking, and pursuant to the jury instruction, there is no evidence pursuant to 17.2a, there is no evidence of a forceful, violent, or an offensive touching on this record. The complainant admits to no injuries, no medical attention, no physical evidence of any touching, let alone a forceful, violent, or offensive touching. Your Honor, a forceful, violent, or offensive touching would have physical evidence of injuries. The complainant admits the entire alleged incident takes place on either audio of hers and his audio and video recording. So the court has been in a position to, at minimum, listen to the entire interaction. Specifically on his recording that the complainant objected to on the witness stand, he says, Bonnie, you have twice lunged at me trying to grab my phone and screamed, I hit you. She replies on the audio video recording, no. He's telling her to get away from him at least 24 times. both before and after any alleged assault. She threatened him, and if the court remembers, in a very calm voice, she says, "I'll call the cops." He tells her point blank on the recording, "I did not hit you." On the video recording, you can see he's still in the bed and she's still standing at the foot of the bed, insisting that he either communicate with her or provide him with his phone. And this takes place after the alleged assault. The second witness, Sergeant Canterbury, testified as a sergeant and a supervisor that he completes detailed written reports. The complaining witness claimed that, according to Sergeant Canterbury on the scene, that Mr. Kennard struck her one time on her right forearm. The forearm, he testified, is the lower portion of the arm. The complaining witness testified on direct examination when either the court or the prosecutor questioned her regarding the positioning on the arm or the portion of the arm where he's alleged to have hit her. She testified the upper area of the arm or the tricep. Lastly, Your Honor, the defense admitted Exhibit 2, Sergeant Canterbury's body-worn camera. After the fact, she asked Sergeant, "Please don't arrest me." After the fact, when the police are on the scene, she doesn't cry or become hysterical until her husband is being arrested for a crime that he did not commit. Thank you, Judge.
Thank you. Any response?
Yes, sir. Your Honor, when considering the motion for the directed verdict, the court must consider the evidence in the light most favorable to the prosecution. Now, defense counsel did just lay out the elements for domestic violence. So in this case, we do have to prove that an assault and/or an assault that would occur under the statute. And the prosecution did not need to prove injury in this case. And although we did not see any photos of injury, we did hear testimony about an injury. In addition, we heard testimony that the complainant was terrified of the defendant, Stephen Kennard, and he also saw body cam and police Sergeant Canterbury's testimony that he observed Miss Stewart afraid and blinking and darting her eyes, indicating that she didn't want to be heard around Stephen Kennard. Again, under the statute, we need to prove an assault and or an assault and battery. And
You know what? I thank you very much. Taking all the evidence in light most favorable to the prosecution, the court finds that a reasonable fact finder could find proof beyond a reasonable doubt. There is still testimony as to whether or not the defendant battered the victim. There was testimony from the victim that she was struck in the arm. There is a dispute, obviously, with regard to where that would have occurred. I acknowledge that there were no injuries. However, an assault and battery does not require an injury. So I'm going to deny the defense's motion.
Yes, Your Honor. May we call our first witness?
You may. Thank you.
Officer Louise Hartado. He's on call room.
you might want to get out.
Okay, thank you.
I'm sorry, who is this? Officer who?
So, last name spelled Hartado.
Oh, Hurtado. I believe it's Hurtado.
Sorry, Judge.
That's okay. All right, sir, you can come right up here, please. And I'm going to ask you to raise your right hand. You solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, sir.
Okay, have a seat, please.
Good afternoon. So will you state your name for the record?
Officer Luis Hurtado.
And are you a police officer with Roseville Police Department?
Yes, I am.
And how long have you been so assigned?
4 years, I believe.
Okay, and on this particular day, 04/03/2026, did you respond to a scene?
Yes,
And was it on the street Canterbury?
yes.
Okay. And when you arrived on scene, did you have a body camera
Yes,
recording both audio and video?
yes,
And you don't have a written police report in this particular case, is that correct?
I do not.
And Judge, may I approach, I would like to mark the officer's body worn camera as defendant's proposed exhibit 3.
You may approach.
Thank
Yes.
you. I am approaching you with what has been marked as defendant's proposed exhibit 3. And I'm not gonna play it, I just wanna, do you see something on the screen there?
Yes,
Okay, and I can play it, I need you to identify, is that your name at the top?
it is.
Would that be your body cam?
It should be. Yes.
And it was functioning on that particular date and at that particular time?
Yes.
And Judge, I move for the admission of this officer's body worn camera.
Any objection?
No objection.
Defense 3 is admitted.
Thank you, Your Honor. When you arrived on the scene, did you encounter the complaining witness in this particular case?
Yes,
Okay. And did she express to you what her desire was regarding the arrest of her husband?
I don't recall if she specifically said something to me. I'm sure she did say something to my sergeant.
Okay.
Sergeant.
And would reviewing your body worn camera that has been admitted into evidence refresh your recollection?
Yes,
By the way, I record all these. I didn't this morning, but I told them to go on. So you're on YouTube for whatever it's worth.
Okay, thank you, Your Honor. Thank you. May I approach the witness again?
May.
Thank you. Or, you know what, the microphone is here, so, well, I don't know. I'm gonna play 7 minutes at the 7-minute and 32-second mark.
Controller to not right now.
Slow down. Can you turn that up a little bit, please?
Sure. I think I'll do what the prosecutor did and stand by the microphone.
That's fine.
Okay, thank you.
You took the microphone to the speaker.
Like this?
Just bend it towards your eye.
Oh. So sorry. Thank you. Did you hear her say that on your body worn camera?
Yes,
Did you hear her say, I don't want him gone, I don't want him arrested?
yes,
Does that refresh your recollection, sir?
yes.
Oh, okay. Now, did you have contact with another individual that was inside of the location?
Yes.
And who would that be?
It would be the son,
Okay, and do you recall the son's name?
at this time, no.
And if I suggested Stewart, does
Yes.
that, it is Stewart, okay. And how old is Stewart, if you recall?
That I do not remember.
If I suggest to you that he's 3 years old, would you?
Maybe I don't remember asking, but I may have.
Okay, no problem. And can we agree that you had communication with Stewart, is that right?
Yes,
And do you recall, Stewart making any volunteering any statements to you?
yes.
Okay, and in fact, what did Stewart say to you when he volunteered?
Right before we were going outside,
Yes,
to go play with them, he said that mommy hit daddy in the face.
okay, I'm gonna play something for you.
So,
Did you hear that?
yes,
Is that what you were referring to?
yeah.
And so is it fair that you didn't ask that baby that question, did you?
No, I didn't.
Okay, so did the baby just voluntarily say that to you?
Yes,
Okay, I'm gonna play something additional. I want you to listen to it. This has been admitted, and then I ask you a question, okay? Was that you? Was that your voice asking Stuart, and then what happened?
yes,
Okay.
Mom's very extreme.
Did you hear what he said?
No, I did not actually.
Okay, I want to play it again. Did you, I want you to listen and tell me if he said, if you heard him say, mommy was yelling and screaming. So I want you to listen for it.
So what happened first?
Sorry, let me take you back, okay? This is the one now, hitting. Okay, it's got.
What happened? Back. No idea? Okay. Happened after mommy hit daddy in the face. Who hit first? Was it mommy or daddy? Mommy hit daddy first. Okay. Were you watching the whole time? It is dirty. Yeah. Were you? Yeah, it does have to run it. Were you watching the whole time or did daddy hit mommy first? Daddy hit mommy first?
Did you hear him say, I'm telling daddy? Yeah.
Daddy, yes.
Yes.
Okay.
It's door. Did daddy hit mommy first? Mommy did?
I'm sorry, Your Honor.
You got a drink what?
I missed, could you please replay that, the last 10 seconds there? Sure. Sure.
Case door. Did daddy hit mommy first?
Nice.
Mommy did?
Okay.
Okay. And so is it fair to say that that was your body worn camera?
Yes.
And that was your interaction with the young steward?
Yes.
Okay, and do you know how many times you asked him, did daddy hit mommy first?
A few times I did.
If I suggest 6, would you agree with that? Does that sound about right?
Sounds about right.
And each time you asked him, did daddy hit mommy first? What was his answer?
It was mommy first.
Thank you, I have nothing to do with it.
Direct, cross?
Yes. So, how long did you say you worked at, for the police department?
4 years I believe so.
And that's for Rosehill?
Yes.
And so I assume you had gone to, or done a lot of domestic calls in the past, is that right?
Yes, and I've done 7 to 8 years of police experience.
Is that total?
Yes,
And 4 years with Rosehill?
4 years, but
And when you arrived at the home on Canterbury Street in Rosehill, is that correct?
yes,
And when you arrived there, you didn't talk to, a man named Steve Dunant, did you?
I don't believe so. I just don't remember if I helped with the handcuffing or anything like that, but I don't believe that I asked him.
And so you didn't take any statements from him?
No,
And you didn't take any statements from anybody buying Stewart that day?
no.
You went inside first, is that correct?
No, I went inside, I think second or third, Officer Tyler.
Oh, I apologize. I meant, was the first thing that you did, was it to go inside the house?
Yes,
And is that where you saw the child?
yes,
He was about 3 years old, right?
yes.
And did you then follow him out to the backyard?
I told him to go to the backyard, just because of the situation going on. I wanted him away from everything, just in case.
So the majority of your conversation with the child was outside?
Yes.
And, you indicated that he voluntarily told you he wanted to get Daddy in the face, is that correct?
Yes.
Did you ask him anything prior to that?
No. I asked him if, where his sweater was, his shoes, stuff like that, but nothing, to the case itself. I was just making sure that he was okay.
Now, it's not typical protocol to speak to the toddler at a scene like this, is it?
Not without like the parents' consent.
And, you never confirmed his version of events, did you?
No,
And if you heard the recording, you asked him what happened after mommy hit Daddy in the face, and he responded, because. Do you recall that?
yes, ma'am.
Would you agree that that's not a typical response to a question like that?
Objection, speculation.
Any response?
Your Honor, I think he can justify his actual knowledge. I mean, a child was saying because after a what question, this is actual knowledge about the response to that.
I'm gonna ask you to rephrase, sustaining the objection.
I can rephrase. So you agree, he said because, right?
Yes,
And you agree that, at that age, the way he was speaking to you, he wasn't speaking like an adult, right?
that's correct.
So you would agree that he wasn't a reliable narrator of the events that happened, right?
In a way,
What do you mean in a way?
a child can definitely see things and repeat them, but I would say not reliable. It's just at the moment there, the victim stated what she wanted to do, and the offender never made a claim about her hitting him. Or at least that was the information that was given to me by my colleagues, just because I was the one actually making the arrest.
So you would agree then that you had information that the defendant never said he was hit, right?
I'm just gonna object to this line of questioning because everyone knows that my client has a detrimental right to remain silent on scene with police.
I'm gonna sustain the objection. If her, but, it's not on Fifth Amendment grounds. It's certainly on the basis that he would have had to have that information imparted to him by another officer, which would constitute hearsay. So unless you lay a foundation that there's an exception, I'm gonna disallow that question.
Understood, Ron. So in the recording you heard, you had asked the child, said, did Daddy hit Mom first? Do you recall that?
Yes,
And, you recall that the next thing that the child told you was Daddy climbed up a tree. Is that correct?
yes,
You would agree that that's not a response to the question you had?
yeah,
So, and you would agree that saying did Daddy hit Mom first was a leading question, right?
yeah,
And you never confirmed whether you never spoke to anybody else after that, right?
no, I did not.
And you never confirmed, Bonnie Stewart's side of the story, is that correct?
From the officer, I did, I believe so, from Sergeant Canterbury, and, but I did not speak about it.
You know, so you were never able to confirm the child's version of events, is that correct?
That's correct.
I have no version.
Any redirect?
That child never said to you that Daddy hit Mommy did.
He never said that, had the dad hit, Mom first.
And no. He never said, period, first, second, third, or fourth. He never said daddy hit mommy at all, did he?
No.
And when he initially said, mommy hit daddy in the face at the 11 minute and 25 second mark, he volunteered that information without you having to pose a question to him. Is that fair?
Yes, it's an exciting utterance, so yes.
All right. You can step down, sir. Thank you. You didn't have any other questions, right? You can step down, sir. Thank you very much. Any other witnesses?
Makes me so nervous. Yes, at this time, I would like to call Mr. Fandar to the witness stand. From our perspective, Judge.
Okay. Raise your right hand, sir. Do you solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
All right, you may proceed.
I indicate your name for the record, please.
Stevie James Kennard.
And have you sat through the trial and heard the evidence in this particular trial?
Yes, I have.
Did you hit your wife?
No, I did not.
Did your wife hit you?
Yes, she did.
Judge, may I approach
Yes.
the witness? Which I'm sure, you know, before I am approaching you with defendant's proposed exhibit number 4. 4, 5, 6, and 7. Defendants, can you identify what you see in defendant's proposed exhibit number 4?
That is my right bicep.
Okay, and do you see anything on your right bicep?
There's several bruises.
Okay, and can you describe for the court what you're wearing, that shirt that you have on there?
That's the shirt that I had on when I was arrested.
Okay, and when was this photograph taken?
That was immediately after I was released, back from the civil stand. Now I retrieved my belongings from my home.
And this photograph is taken inside of your home?
That photograph was taken at my mother's house.
At your mother's house, okay. And defense moves for the admission of defendant's exhibit number 4.
Your Honor, I'm gonna object. We have no way to authenticate this photo. It doesn't have a date, it doesn't have a time. We are solely relying on his testimony that it happened immediately.
That's subject to cross-examination. It accurately reflects how your bicep looked when you were released.
Yes, sir.
Defense 4 is admitted.
I am showing you what is marked as defendant's proposed exhibit number 5. Can you identify that photograph, sir?
That is my right hand, my index finger, and the inside of my knuckle.
And what do you see on that photo?
That's a cut on my inside of my finger.
Was that photograph taken at the very same time that defendant's 4 was taken?
That's the very same time, yes.
Move for the admission, Judge.
Any objection?
I'm gonna restate my single objection.
Does that accurately depict an injury that you received when your
Yes, sir.
wife assaulted you allegedly?
Yes, sir.
Defense 5 is admitted.
Thank you, Judge. I am showing you defendant's proposed exhibit number 6. Can you identify that photograph, please?
That's the first photograph you showed me?
Nope, I'm sorry.
Yes.
Is that a closer up
That's a
photograph?
closer up, yes.
Okay, and does that accurately reflect your arm on the date and time that your wife allegedly assaulted you, sir?
Yes, it does.
Move for the admission, Judge.
Same objection? Defense 6 is admitted.
Thank you, sir. Nothing further.
Cross?
Yes, sir. Yeah, please. Sure, you can. Well, that's okay. When I get out.
Okay.
So you were with Bonnie Stewart on April 3rd, 2026, is that right?
Correct.
And that day you had some kind of argument, not only with Bonnie Stewart, but with your ex-lady president and Ashley.
Correct.
And it was something about the custody of the children you have with Ashley. And, so around that time, you were pretty frustrated about this argument that you had with Ashley, right?
Correct.
And following that, you then began arguing with Bonnie Stewart, is that right?
Correct.
There was a point in time, if you have heard from the testimony today, following this argument, you went upstairs to her bedroom, right?
Yes.
And you have a son with Bonnie Stewart, and is that right?
Yes.
And at some point he came to your room with some kind of ice cream sandwich.
Yes.
And you were frustrated and you kind of dismissed it, right?
Yes.
And Bonnie then went to talk to you about that, is that right?
Yes.
So,
Judge, I'm just gonna place my objection on record and then I'm gonna sit down. It is outside the scope of direct.
Yeah, it's us.
I.
Overruled.
Move on.
It's overruled.
Now, you indicated to your counsel that, you were injured from that day, right?
Correct.
Now, when the police first arrived, did they arrest you right away?
2 minutes and then leaving home, they arrested me.
You spoke to them prior to being arrested, right?
Brief, yes.
You never voluntarily told them that you were injured at that time, right?
Judge, I'm sorry, I'm just gonna place the same objection on the record. He has a right to remain silent when he is encountered by police.
Your Honor,
He does have the right to remain silent, but he wasn't in custody at the time, so I'm gonna overrule the objection.
Thank you, Judge. And just so that the record is clear, he said that he was arrested within 2 minutes.
I heard that.
Okay, thank you, Judge. I appreciate the court.
so you did speak to the police prior to arrest, right?
Yes.
And again, you never told them that you were injured that day,
Before you were placed in custody.
Before I was placed in custody.
and you never told them, before you were placed in custody that Bonnie Stewart had been, right?
Correct.
And, it wasn't you that called the police, right?
Correct.
But you're indicating today that you were injured, right?
Correct.
And you didn't think to call the police after getting injured?
No, we're in the process of a divorce. I filed for divorce. We were working on our marriage and I don't want to see anybody be arrested. And we don't know who called or anything.
When did you file for divorce?
I filed in November last year.
So the divorce had been ongoing for about 5 months?
Correct.
And you two still living together at that
We
point?
were still living together.
So. You heard those recordings. In those recordings, you never at any point indicated to her that she hit you. Am I right?
Correct.
But at some point you heard her say that she said, "Why did you hit me?" To you, correct?
Correct.
And in those recordings, you were pretty confrontational, wouldn't you agree?
Yes.
There was an argument, right?
Yes.
So you were pretty angry.
Yes.
And, again, at no point did you indicate to her or even to police prior to arrest that she did you. Is that right?
Correct.
So, given that you're indicating that she had hurt you, you never left that day, did you?
No.
You could have left home, right?
I could have left home. Correct.
If she had hit you, wouldn't you have been placed in fear?
She stated she was reading.
But you didn't think to leave the situation,
No.
even though you were hurt.
Correct.
I have no further questions, Your Honor.
Any redirect?
No, Your Honor.
You can step down, sir. Thank you very much. Call your next witness.
Judge, at this time, the defense rests.
Any rebuttal?
Rebuttal witnesses, Your Honor?
Yes.
No, Your Honor.
Are you ready for argument?
Yes, Judge. Yes.
You can go ahead, whoever wants to. If you want to go get the victim, she's welcome to come in now. Go ahead, Ms. Holloway.
I think, looks like somebody else is doing
That's
that.
fine.
Your Honor.
Take your time. Do you want to take a couple minutes and gather your thoughts? If you do, I don't mind.
Most of it right here.
Okay.
Again, Your Honor, we had two people in our case in chief testify today. We had Bonnie Stewart and we had Sergeant Canterbury. Your Honor, Bonnie Stewart had testified that the defendant, Stephen Kennard, had hit her on the arm once with an open hand. And the Sergeant Canterbury also testified indicating that he arrived to the residence. He saw that she appeared to be fearful and that he wanted to take her outside to get out of the situation because of, based on his experience and knowledge, that she appeared to be afraid to speak in front of Stephen Kennard at that time. And after that, he did speak to her and she indicated to him the same thing that we heard today, that she was hit on the arm by Stephen Kennard. We heard recordings, first a recording made by Bonnie Stewart, where at the end you hear some rustling and you hear, "Why did you hit me?" At no point do we hear that she hit Stephen Kennard. At no point was a statement made like that to police. And at no point did Stephen Kennard say that he was injured. The domestic violence statute requires that an assault and or assault and battery be made. It does not require injury. As you know, the definition for assault is for a reasonable person to be placed in fear of an immediate battery, and the definition for battery is for that forceful, offensive touching of another or something closely connected to that person. Your Honor, we heard sufficient testimony today that she was placed in fear of, and she said herself she was terrified. She said she was terrified to even call the police in front of him. We saw video, and we heard from the officer of his observation that she appeared fearful. At the very least, an assault was proven beyond a reasonable doubt here, and we would ask that you find it.
Thank you.
Very quickly, John.
Sure.
There's reasonable doubt. The burden of proof. They are the foundation for which our criminal justice system is so deeply rooted. Simply put, Your Honor, from a defense perspective, the prosecutor has failed to prove her case beyond a reasonable doubt. The beauty in this particular case is that the court was in a position to hear the entire incident from beginning to end based on the audio recording from the complainant and the video and audio recording from the defendant, Mr. Kennard. Your Honor, my client stands before this honorable court charged with a very serious offense. There was nothing based on her actions that were recorded on video footage from the police, the body-worn cameras, that would ever suggest that she was placed in fear of apprehension of an immediate battery. In fact, her actions suggest just the opposite, Your Honor. And as I indicated in my opening, initially to this honorable court, I indicated that she followed him, which would be indicative of her not being in fear of an immediate battery or an assault, that he kept saying, "Leave me alone, just go." And that she refused to leave him alone and just go. In fact, specifically on her audio recording that was admitted by the prosecutor, he said, "Go, leave." And she responded on her own audio recording, "I don't want to leave. I want to be here with you, but you're not letting me." She continues to antagonize him. The court is able to see her standing at the foot of the bed, and this is after she makes the allegation of some kind of physical touching. In fact, Judge, the evidence is clear. When she indicates to the officer on body-worn camera, "Please do not arrest me," because she was aware that she had had contact. I published this to the court.
Sure.
She was aware that she had had contact and had assaulted Mr. Kennard. And as a result, he sustained the injury, the bruising to the right arm area. She was confused, not realizing that, in 2026, everything is either video or audio recorded, and the video footage from Canterbury would establish that she had no injuries, that she indicated that she didn't even want to discuss that. When she indicated on the body worn camera, Your Honor, please don't arrest me. To me, that spoke volumes, because that was indicative of her knowing that she had assaulted Mr. Kennard. And then what I find more interesting than I have ever in all of my years is that the child, who is as sweet as pie and is innocent, volunteers to the officer, and is captured on body worn camera. It was the defendant's admitted exhibit. He volunteers. His exact words were, "Mommy hit Daddy in the face." The officer is doing his very best to communicate with this young child, and he asked this young child 6 times, and the child never wavered. He insisted that he was present when Mommy hit Daddy. And Judge, I'm going to conclude this. Of course, I'm going to ask the court to find my client not guilty. But this is what troubles me, Judge, and I know it's Friday evening. Perhaps my client didn't have an audio or video recording of this particular incident. He might be differently situated. Perhaps Rose Hill Police Department didn't have body worn cameras. He would be differently situated as he stands before the court. But in 2026, thankfully, there is audio and video evidence that we as defense counsel can provide to this honorable court on behalf of my client to show that not only is he not guilty of this offense, but he was the victim on that particular day. And as the court knows, he's not obligated to give any information to the police. When the police come to the scene on a domestic and you have a woman that's moving her eyes, and the police don't know, they weren't there. They can only give the information as it is given to them and based on their own perceptions, based on officers' experience. Based on officers' experience, they did the right thing in arresting him. Did they do the wrong thing? Ultimately, absolutely, because he was the victim. And Judge, I'm not a man. But me and I'm macho. And so I can't see my client saying to the police, "She hit me on my arm," nor was he obligated to do so. The fact is that the court has admitted the evidence to substantiate that he was the victim on this particular day based on the photographic evidence that was admitted. And with that, Judge, I would ask this honorable court, I know the court has been listening, and I can see that the court is taking meticulous notes, and we appreciate the court. I would ask the court to find my client not guilty. Thank you, Judge.
Briefly, Your Honor, in response to defense argument, again, the crux of defendant's case is relying on the defendant and the officer Furtado. It's important for the court to consider the credibility of his two witnesses. First, the defendant submitting photos of injuries and even knowledge or any discussion of his injuries way after the fact. Even he had not told the police about any kind of injuries prior to arrest. He told nobody. There was no indication of him being in fear or of him being hurt in the recordings. And again, as per the officer, in his duties, not to deny the credibility in the course of his duties, but again, the credibility of who he spoke to. He spoke to a 3-year-old. He was relying on the narrative of a 3-year-old. He never confirmed the version of events that this 3-year-old had. And again, I would ask that you find the defendant guilty based off of the prosecution's evidence.
Thank you very much, both of you. All right, the defendant is charged with domestic violence. in order to prove this charge, the prosecutor must prove beyond a reasonable doubt each and every element of the crime. They must prove that this incident occurred on or about April the 3rd of 2026 in the township of Grosse Ile at 21615 Canterbury. Also, they must prove beyond a reasonable doubt that the victim and the defendant were married at the time. At least that is the allegation. There are others that would qualify, but clearly they were spouses at the time. Prosecutor also must prove that either an assault or an assault and battery was committed beyond a reasonable doubt. A battery is the violent, forceful, or offensive touching of the person or something closely connected with her. The touching must have been intended by the defendant, that is not accidental, and it must have been against the victim's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended to commit a battery or to make Bonnie Stewart reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability to commit a battery, or must have thought he had the ability to commit a battery. A person accused of a crime is presumed to be innocent. And this means that that presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless the fact finder is convinced that each and every element of the crime has been committed beyond a reasonable doubt. In this case, the facts are really pretty straightforward. We have the victim testifying under oath that she was struck in the right arm by the defendant. According to the police officer, when asked at the scene, she pointed to her forearm. When the court asked her in questioning, she pointed to her tricep. When the defense lawyer was questioning her, she pointed to her bicep. That is an inconsistency. The entire recording that supposedly captivated this assault was only by audio. There was no video. There was rustling at the end, and the victim testified, "Why did you hit me?" She continued to stay there, and Mr. Kennard, and when I say there, I mean upstairs in the bedroom, and it was clear that the two continued to argue. Mr. Kennard kept telling her, "Go ahead and leave, take your pillow." But at all times, it was pretty clear to the court that the defendant was videoing the incident. The victim testified that she did not know whether or not he was recording the incident, but then again said twice, at least twice that I know.
Agent Bauer, do you recognize that document?
Yes, I do.
Okay, can you tell the court what it is?
It is a copy of Ms. Lumen's 2022 U.S. individual and state tax from Liberty Tax.
Your Honor, I've sent counsel a copy of these records along with the 90211 certification, so I would move for the admission of those records.
Any objection?
Judge, no objection for exam.
Peoples 2 was admitted.
Thank you. Agent Bowers, in that tax return for 2022, did Ms. Lumen report income?
Yes, she did.
Okay. Approximately how much?
Around 66,000.
Dr. Rorschach?
You may.
And Agent Bauer, was part of this income relating to a company called Total Defense?
Yes, it was.
Judge, this is the last one.
Okay, we'll mark that Peoples 3.
Yes, thank you.
Some.
Agent Bauer, I'm handing you what's been marked Peoples 3. Do you recognize that document?
Yes, I did.
Okay, can you tell the court what it is?
That is a LARA filing document for the Business Total Defense LLC.
Who does it list as a registered agent?
Ms. Lumen.
And Your Honor, I would move for the admission of People's Proposed 3 under 9024, it being a public document that bears a seal of the state of Michigan or an agency, which would be law.
Any objection?
No.
People's 3 is admitted.
Judge, I have nothing else. Thank you.
Cross?
Yes, Judge, thank you.
Good afternoon, sir.
Good afternoon.
Sir, you are an investigator with the OIG, correct?
Yes, I am.
How long have you held your current position?
5 years going on 6 years in March.
Understood. And it's my understanding, based on your testimony, that generally speaking, you are responsible for conducting investigations as it relates to welfare fraud, correct?
Yes, I am.
And obviously, in order to do your job and determine whether or not fraud has, in your opinion, been committed, you need to be familiar with definitions of things such as income, correct?
Generally speaking, yes.
Okay. Well, an individual has to qualify to receive assistance benefits, right?
Yes.
And in order to qualify, an individual must not exceed a set income level. Fair?
Correct.
So income is something that you consider each and every time you are investigating an allegation of fraud. Correct?
Most of the time.
Okay. And thus you need to know what in fact constitutes countable income. Correct?
Correct.
You would agree with me that income is money actually received by a person. Fair?
In terms of the department, they have different standards in terms of self-employment, general income. So if you were working for Ford Motor Company, unearned income, stuff of that nature. So without the actual purchase policy manual, specifically relating to self-employment income, I cannot give you a yes or no answer to that.
Okay. So you are not, at this point in time, off the cuff, familiar with every category of potential income. Correct?
I review policy manuals in terms of income when I am reviewing cases for potential allegations of welfare fraud.
Okay. Would you agree with the general statement that income is money that an individual actually has access to or has been provided?
Again, in general, with self-employment income, so for example, depending on what self-employment is categorized, so a sole proprietor, partnership, depending on how it is categorized, the department budgets that income differently. So for example, a sole proprietorship, they would take like 15% of that countable income, they would look at the gross receipts of sales and stuff of that nature. So.
Understood. Well, let me ask the question a different way.
Okay.
Obviously, assistance benefits, including food assistance benefits, provide individuals with money to purchase food, correct?
Correct.
If an individual, let's say, is involved with a business but receives no payments, wages, salary, or earning, you would agree with me they don't receive money, correct? Yes?
Yes.
And thus they don't have money available or accessible to them to purchase food.
If that was the case.
Understood. Now, you indicated that you conducted an investigation as it relates to Ms. Lumen, correct?
Yes, I did.
And your investigation of this matter commenced with a referral you received in November of 2023, correct?
That is correct.
Who sent you this referral?
The data analytical unit
Okay.
in the Michigan Office of Inspector General.
And can you tell me a little bit about the data analytical unit? And-
Yes,
Go for it.
so for example, the data analytical unit will run quarterly checks or bi-yearly checks for certain things such as parents matches, which is legal assistance cases. They have an agreement with the Michigan Treasury Office where they will review adjusted gross income. And then they will make a referral to actual agents to investigate those referrals further.
Understood. Do you know, based on your personal knowledge, how
Ms. Lumen came to the attention of that office?
Her adjusted gross income, was higher than what was being budgeted onto her face.
Okay, understood, meaning, her tax returns were reviewed. Fair?
Yes, sir.
And it did not match the Bridges application or redetermination, correct?
That is correct.
You provided testimony regarding the redeterminations you claim Ms. Lumen did.
Yes,
You
I,
recall that? Redeterminations are completed utilizing a computer, correct?
or you can complete them in person.
Understood. In this case, they were completed utilizing a computer, fair?
That's correct.
And no one from your office was present at the time the redetermination form was completed, fair?
Yes.
Meaning it was completed remotely and submitted, right?
Correct.
You did not personally observe Ms. Lumen complete the redetermination forms that you provided testimony regarding and which have been admitted into evidence, correct?
No, I did not.
To your knowledge, did any other agent of the government observe Ms. Lumen complete those applications, or excuse me, redeterminations?
I'm sorry, can you repeat that?
Did any other agents from your office or the government observe Ms. Lumen complete redetermination?
No one from my office, and I do not believe it.
Okay. Now, the redetermination form that was completed, obviously, you cannot testify that Ms. Lumen in fact completed it. Fair?
Yes.
You don't know who may have completed it, correct?
Well, I would add, she completed interviews with the department after,
I understand. I didn't ask about interviews. The redetermination form. You did not observe her complete. Right? You do not have personal knowledge establishing that she in fact completed it, correct?
during our interview, she did not, dispute any sort of nature of not receiving benefits or completing any applications, so I have no reason to not believe that she is not the individual completing any applications or redeterminations or interviews with the department.
Right, you have no reason to believe it, you don't have actual knowledge. Fair?
Yes.
Now, the redetermination form, has a number of categories within it. Fair?
Yes, it does.
One of the categories relates to financial circumstances, correct?
Yes, it does.
And it asks individuals if they are employed, correct?
Yes, it does.
And in this case, the redetermination form indicated that Ms. Lumen was not employed, correct?
Yes.
You would agree with me that the redetermination form does not include a definition of employment within it, correct?
She would be notified in a rights and responsibilities.
I'm sorry, my question was, does the form include a definition of employment?
No, it does not.
There is a section which indicates, under the financial title, does your household have any additional income, right?
Yes.
You would agree with me that the redetermination form does not define what constitutes income, correct?
Yes.
And as you've already indicated, the concept of income when it comes to your department is quite complex.
I would not call it complex in terms of what the client is supposed to report based on their rights and responsibilities and what is outlined to them, specifically during interviews when an eligibility specialist will review those rights and responsibilities and income.
Sure, but if an individual isn't familiar with, let's say, legal concepts or financial concepts, it can be difficult to determine what constitutes income. Do you agree with that?
I would,
I'm sorry, would you say I would not?
I would not.
On the redetermination form, does it indicate that income is money actually received by you?
I'm sorry, can you state that again?
On the redetermination form, it does not indicate that income is money actually received by you, meaning the person that completes the form.
That would be correct. Although it does ask for household income.
Sure, with no definition. Now, throughout the course of your investigation, you actually obtained tax returns, correct?
Yes, I did.
And I'm assuming after you obtained those tax returns, you reviewed them, correct?
Yes, I did.
And you're familiar with the entirety of those tax returns, meaning for 2022 and 2023.
The relevant pages, yes,
What are the relevant pages in your opinion?
would be the business income.
Meaning the schedule that is attached to the individual tax return, correct?
Correct.
The schedule that is titled qualified business income, correct?
Yes.
Do you know what the definition of qualified business income is under federal law?
I do not.
Do you know what qualified business income, as defined under federal law, is different from income under your office's guidelines?
I'm not aware.
Does your office have a policy relating to Schedule C, meaning as part of a tax return for qualified business income?
Yes, they do.
Specifically, as it relates to qualified business income?
To self-employment income and tax returns in general, yes, there is a section, Bridges manual policy.
Okay. You would agree with me, qualified business income is a tax classification, fair?
Yes.
You would agree that qualified business income does not require money to actually be paid to the taxpayer that's filing the Schedule C.
I'm not aware of that.
Are you aware that business can report qualified business income even if an individual affiliated with that business does not receive a single dollar from the business operation?
I'm sorry.
I didn't hear your answer. Hang on one sec. We got a train going by here. I did not hear your answer to that last question.
I was going to say yes in the sense that gross receipts of sale or in terms of a partnership with Total Defense LLC is total income that is listed on that tax return, which was utilized to budget, which she failed to report.
So your answer is yes. A business can report qualified business income, notwithstanding the fact that someone affiliated with the business gets $0 directly.
I am unsure on that.
Okay. Do you know if qualified business income can simply be retained by the business for purposes of operation?
I'm not aware of that either.
If the business generates income and that income is exclusively used to pay for the operations of that business, is it income under MDHHS guidelines?
I believe it would be.
Do you know?
I would have to review the policy manual.
So you don't know. Fair?
I would say that's fair at this moment.
It's my understanding you obtained the relevant tax returns from Liberty Tax Service, correct?
That is correct.
And you were provided with those records by an individual named Sam Catone.
For 2021 and 2022.
Did you ever speak with Mr. Catone?
Over email and I believe twice over the phone.
Did you ever interview him regarding the information that was contained in the tax returns?
No, I did not.
Okay. You are aware that he is the tax preparer, correct?
Yes.
Meaning he is the one who prepared the documents that you reviewed and ultimately concluded indicated qualified business income, right?
Correct.
Since you never interviewed him, you never determined where he received the information that he included in the tax returns, correct?
Correct.
Since you reviewed the records, you are aware that at the end of the returns, the tax preparer makes some attestations regarding what's contained in the records, right?
Yes.
And one of those assertions by the tax preparer is that he received information from a number of sources, correct?
I don't believe, did it state a number of sources at the end?
I'm asking you generally, I'm not reading verbatim, but the affirmation at the end of the return that is completed by the preparer, you reviewed it, right?
Yes, I did.
And you are aware that the preparer attests that he received information from a source or sources, right?
Yeah.
That attestation effectively indicates that the preparer received the information either from the taxpayer, a third party, or collateral sources. And in this case, you don't know which, correct?
That would be fair.
You did not observe Ms. Lewin provide Sam Catone with any documents as it relates to Total Defense LLC, correct?
That is correct.
Did you determine whether or not Mr. Catone obtained any records relating to Total Defense LLC?
Yes, I did. He provided me with tax documentation that he utilized to prepare Ms. Lumen's tax returns for 2021 and 2022 as part of a request for certification of the tax return documents.
Okay. Did you review those documents?
Not in their entirety.
Do you know who provided those documents to Mr. Catone?
The way he responded in the email,
No, I'm asking you, do you know who provided those documents to Mr. Catone?
no, I didn't know.
Now, in the Schedule C, which is qualified business income, approximately $62,000 was listed, correct?
I believe it was closer to 66,000.
I'm sorry, maybe I can't read my own handwriting. A number was listed, right?
Correct.
Okay. Over 500.
Yeah.
Right, okay. Throughout the course of your investigation, did you obtain any bank records for Total Defense LLC?
Not for the business.
Did you determine whether or not any distributions were made from Total Defense LLC to Ms. Lumen directly?
Not that I can identify.
So you cannot confirm that Ms. Lumen received an amount in excess of $60,000 from Total Defense LLC.
I cannot.
Do you know how many individuals are affiliated with Total Defense LLC?
Based on Lara filing, she's a resident agent, so
Do you know what a resident agent is?
she's just the individual listed as the individual that held the records, information such as that.
Okay.
She's not listed on the articles of the organization, but when I spoke with her during the interview, she indicated that she went through LegalZoom to incorporate the business, which matches up with the articles of the corporation.
Okay. Obviously, you have never seen her perform any work for the LLC, correct?
That is correct.
You have no information indicating she ever received wages or a salary from the LLC, correct?
Other than her tax return file.
Well, that's qualified business income, not distributions. Fair?
That is fair.
So nothing throughout the course of your investigation directly established that she received $1 of income actually from Total Defense LLC.
Yes.
Throughout the course of your investigation, were you able to determine whether or not the qualified business income for the LLC in question was simply used for operating expenses for that business?
Can you repeat the question?
Yes, throughout the course of your investigation, did you ever determine whether or not the qualified business income that was listed for Total Defense LLC was simply utilized to pay expenses or operate that business?
I did not verify if it was utilized for expenses.
Now, during your investigation, you did reach out to Ms. Lumen, correct?
Yes, I did.
And you spoke with her regarding this matter, correct?
Yes, I did.
You would agree with me that she specifically informed you that she had,
Objection, Your Honor, that would be hearsay.
but he has testified repeatedly to what Ms. Lumen allegedly stated during the interview. I think the door's open and I have a right to follow up.
And
That-
I acknowledge what
No,
I know.
no, sustained.
Thank you. Did you determine whether or not Ms. Lumen reviewed the tax returns that were filed on her behalf by the Liberty Tax Service?
She verified that she was.
Judge, I'm gonna object to hearsay at this point.
Any response? Sustained.
I'll ask the same question, but I'm asking that you don't respond by stating what someone else said. Do you have any, actually strike that. Did Ms. Lumen, based on your review of the tax returns, actually sign her tax return?
There is no signature from her, but there is a signature pin number indicating that she did sign the document.
No, indicating that the tax preparer did in fact have authorization to submit on her behalf. Correct?
Yes,
But obviously you have no personal knowledge as to whether she reviewed that document for accuracy, correct?
correct.
If she was personally aware or had actual knowledge of the qualified business income that is listed on the return, correct?
Yes,
If she knew that qualified business income as listed on a Schedule C from a tax return was the same thing as income under your department policies,
I would believe she would be aware that it is.
you would believe that. You do not know. Fair?
Correct.
Thus, you cannot indicate whether or not, when she checked no income on the redetermination form, whether she knew that qualified business income was in fact income.
Yes,
And thus, whether or not her checking no in the redetermination form was not a truthful statement. Correct?
no, I would not agree with that, based on her rights and responsibilities and her being explained income.
You didn't explain it to her, right?
I did not, that is correct.
You were not present at the time anyone allegedly may have, if ever, explained it to her, correct?
It is indicated they were explained to her.
I understand, you were not present, right?
Correct.
So all of the testimony you just provided, meaning her being advised of rights and responsibilities, that's based on hearsay, meaning what third parties allegedly informed you of.
I would say no, just based on the rights and responsibilities appear at the end of applications. There's also a notice under redeterminations that indicate penalties for providing incorrect information. Again, during interviews, the department will review the rights and responsibilities with the client.
Give me 1 second, please. I'm sorry, Ms. Barker.
No, you're okay, Judge. Sir, you indicated the rights and responsibilities are listed at the conclusion of the predetermination form, right?
Not the full rights and responsibilities.
Okay, well, there's a rights and responsibilities section, correct?
They come in a packet, yes.
No, I'm asking you on the redetermination form, is there a rights and responsibilities section?
No, there is not.
May I approach the witness, Judge?
You may.
Thank you.
What do you have there? Can you identify that, please?
I'm not sure what exhibit this was. You submitted them in bulk.
It'd be one, it's a part of the redetermination forms. Oh,
Yes.
so part of people's one, Judge.
Okay, can you tell me what's at the top of that, please?
It indicates an assistance application, so on MDHHS 1171.
Okay.
This is not a redetermination.
So on the assistance application, which is the initial step, there is a quote unquote rights and responsibilities section, correct?
That is correct.
And you would agree with me that that does not indicate or define what income is, correct?
That is correct.
And on the redetermination, the same exact rights and responsibilities statement is included. Fair?
Fair.
Thus, on the redetermination form, it does not indicate under rights and responsibilities what constitutes income and what does not.
So when you complete
Hold
it,
on the redetermination form, does it indicate what constitutes income under rights and responsibilities?
no, it does not.
So nothing on the forms that Ms. Lumen allegedly completed and submitted to your department, is there any indication as to what the actual definition of income consists of?
I would request to review the, I believe it was Exhibit 1, the application. I believe there is a section that specifically asks for self-employment income.
I asked you if it defines.
All right, but he's entitled to look at the document. Do you have the document, counsel?
Well, Judge, I have the part that I did. There's obviously a larger section. If you want to look at the bigger section.
It would just be under income, so it would just be one of the pages.
Okay, well, here, approach, Judge, this is.
And you could hand him that and you take your time looking through it and then you can answer the question.
Okay. So I would just like to note that under the income section, it does specifically ask about household self-employment. That employment seen on her 2022 and 2023 tax returns would constitute self-employment.
Self-employment requires an individual to actually work for a company, right?
Correct.
Perform work in exchange for monetary compensation. Fair?
Yes.
You've already indicated that you never determined through your investigation whether or not Ms. Lumen actually performed work for Total Defense LLC and received actual compensation, meaning money in hand from the business, correct?
Yes.
You indicated that the application and or redetermination form simply asks is anyone in your household self-employed, right?
Correct.
Neither form defines what amounts to or constitutes self-employment or what makes an individual self-employed. Fair?
I think as an individual, you have an awareness of what is self-employment, especially based on the Lara records, the fact that she's associated with the business.
So she's a registered agent. Right? That's it.
Correct.
And I asked you this earlier, but you'd agree with me that a registered agent can simply be someone that accepts, let's say, service on behalf of an LLC or other business entity, right?
They could.
That doesn't mean they work for the entity officially, meaning provide services in exchange for money, correct?
I suppose.
So just to get a clear answer, it doesn't define self-employment or what it means to be self-employed, correct?
Not on the application.
And it also does not provide any information regarding what constitutes income and what doesn't. Fair?
That would be fair.
Thank you. No further questions.
Redirect?
Yes, sir. Let me go back. Agent Bowers, as part of your investigation, did you run a lien check on Miss Lumen?
Yes, I did.
Okay. And did a photograph, come up with respect to Miss Lumen, those records?
Yes, it did.
Is the person that you identify as Miss Lumen, the lien check present in the court today?
Yes, she is.
Okay, is she sitting at defense counsel table?
Yes, she is.
Okay, but not the one questioning you?
No.
Okay, Judge, for the record, I'd like the defendant's identification to be
The
noted.
record should so reflect.
Thank you. Agent Bowers, when somebody begins the application process for FAT benefits, you said they had an interview, is that correct?
That is correct.
Generally, what is explained to them during that interview?
But I'm just gonna object, it's not relevant. He didn't conduct the interview. He can't attest whether or not the same statements were allegedly made to Miss Lumen at any point in time.
I'm gonna ask that you lay more foundation. I'm gonna sustain that.
Thank you.
Agent Bowers, when somebody applies for FAT benefits, what's the process in which they go? How does it work?
So after the department receives the application for assistance, they would then schedule a interview with the client. So they would contact the client, send them notice for an interview.
The client being the person who's applied for benefits.
Correct.
Do those interviews take place in person, over the phone, sometimes both?
Sometimes both. It will be indicated on the interview guide, whether it was conducted over the phone or in person.
And as part of the larger part of the Bridges records, are there records of Miss Lumen being interviewed?
Yes, there is.
Okay. Does somebody get FAT benefits if they've never been interviewed?
They should not.
Generally, what is discussed during an interview for someone who's applied for benefits?
Judge, I'm just gonna advance the same objection. I heard your ruling. I understand he's laid a little bit more of a foundation, but I don't believe this to be relevant for purposes of the hearing because it has no direct relationship to it.
How about, is there a policy or procedure employed by agents in interviewing FAP applicants?
So my interview process would be slightly different than the department's interview process. So the department, they will request personal identifiable information such as social security number, date of birth, home address, information that in general a client should be the only individual that would have access to or be knowledgeable of. And I believe on the interview guides in the exhibits, it would indicate those questions were asked.
And I guess to put a finer point on it, you said there are roles and responsibilities that somebody has if they're going to receive FAT benefits. Is that correct?
That is correct.
What are some of those roles and responsibilities as it relates to income?
So again, the client would be made aware that that is something the department needs to know based on their applications. The interviews, they are directly asked, is there any self-employment? Is there any general income, such as if you were employed with a grocery store, or if you had unearned income such as disability income or unemployment benefits. The rights and responsibilities, the big thing regarding those is it's a large packet and it dictates some certain policies in terms of what the client is required to do. In this case, what is relevant is her failing to report her change in income to the department, and that would be Total Defense LLC.
The records that you received from Liberty, there are a number of different things in here that council referred to. But I think
The fourth page, that entitled U.S. Individual Income Tax.
Is that People's One?
No, Judge, I'm sorry, this is People's 2.
Okay.
It's entitled U.S. Individual Income Tax Return, is that correct?
That is correct.
And on this form, I'm just gonna hang up here for a second. On this form, her income, other income from Schedule 1, line 10, is that $66,775?
Yes, it is.
And that amount, or any amount, was not reported in her application in 2022. Is that right?
That's correct.
And just to make clear, in 2022, from January 1 to December 31,
Do you know exactly how much in benefits Ms. Loomis received?
So based on a household of, I believe, 4 or 5, depending on how many children she reported as being in her household, I believe she was making well over 800 in food assistance program benefits.
800 per month?
That is correct.
Agent Bowers, is the exact amount written in your report?
It would not be, but no, it would not be. It would be the exhibit right before the overissuance budget in the report where it indicates she received fat benefits.
Judge, can I approach?
You may.
That number right here.
What are you referring to?
Hey, Judge, I'm asking about his report. So let me ask this question again.
What exhibit is that?
It's not an exhibit, Judge. I'm gonna refresh his recollection with it.
Okay.
Do you recall indicating how much he received easy for me to say, how much he was over issued in benefits during the year of 2022?
Yes,
Okay. Is that the number? Do you remember how much that was?
a little over 13,000.
Okay. That's how much she received in fat benefits that she was not qualified for because of the income she did not report. Is that correct?
That is correct.
Nothing else, just saying.
Any other questions?
Sir, the prosecution asked you about the defendant's individual tax. You recall that, right?
Yes,
And he directed your attention to additional income, correct?
yes,
And it listed $66,775, correct?
yes, it did.
And you reviewed the document, you are aware that that is what is listed on the Schedule C, meaning qualified business income.
Yes, it is.
And I think I asked you this, I'm not sure if I did, I'm sorry for repeating myself, but you do not know whether there is a difference between qualified business income and income as defined by your department.
I'm not aware of this time.
You provided testimony indicating that generally speaking, when someone applies for benefits or assistance, they are provided with materials, right?
Prior to signing their name, they are offered the rights and responsibilities and are required to review them prior to signature.
Okay. Like anything you signed, read thoroughly before signing, correct?
Yes,
You have no personal knowledge as to whether or not this woman actually reviewed the records, documentation, and or information that was allegedly, if ever, provided to her, correct?
she signed the document, so I would be under the understanding that she reviewed it as required.
That's your understanding. Do you have knowledge
establishing that she in fact reviewed it?
Well, that's not an issue with the department.
Can you just answer the question, please, sir?
No, I do not.
Thank you. Throughout your investigation, you would agree, you never determined whether or not Ms. Lumen was directly familiar with the entirety of the definition of income established by your department.
You know, we have covered this, haven't we? I mean, I think he said it multiple times. I mean, if you don't feel like you've hammered in the point, you can continue, but I think he certainly has acknowledged that at least 3 times.
I was hoping to receive a direct answer to that question. He's provided a.
Go ahead and answer the question, sir.
Can you repeat the question?
Yes. Throughout your investigation, you would agree with me that you were unable to determine whether or not Ms. Lumen had actual knowledge of the entirety of the definition of income provided by your department.
I would say yes, based on the interviews, but again, I'm under the belief, based on policy and all that the department would make her aware of what needs to be reported in terms of income.
Sure, the department would attempt to make someone aware, right?
Correct.
But you do not know, and you could not determine whether or not she actually understood what the definition of income established by your department was.
I suppose.
No further questions.
You can step down, sir. Thank you. Any other witnesses?
No,
People move to bind over on count 1.
I do, Judge.
Any response, Ms. Barkovic? You agree this is a fact question, do you not?
Well, Judge, I actually don't agree with that. I don't think that there has been a showing that the defendant engaged in intentional and knowing fraudulent conduct here and made actual fraudulent misrepresentations. You heard the investigator testify that there is no definition of income listed on the application or redetermination. I understand they have a generalized policy as it relates to applicants receiving information from the department. And I know that this isn't a matter of record, but I have thoroughly reviewed all of the policy and procedure manuals from the MDHHS. And it is, in fact, extremely confusing. There is a long list. I think the manual on income is about 100 pages, if I'm not wrong. It's extensive. It lists in generalized terms what may constitute income. It defines income as money or remuneration received by an individual for services performed. That is the general definition of income, and there's no indication of that on this record. Furthermore, there's no indication that Ms. Lumen, in fact, received any money from the operation of this business. I think that's clearly established by the testimony of the investigator. And thus, when she checks the box on the form that says no income, it may have in fact been true. The people at this exam are required to establish that she intentionally and knowingly made a false statement in order to receive benefits or engaged in some fraud to receive benefits, and they have not done that on this record.
Okay, thank you.
So I'm asking that you dismiss the remaining count of welfare claims.
So,
Judge, I have no response. People still need to bind over. Well, I'd say back, I'll make a very quick response. Judge, the agent testified that when someone applies for FAT benefits, there is an interview process. They are given roles and responsibilities. They are told what they are responsible for or not. Ms. Lumen has indicated in all of these forms that she understood that she would follow the rules. The rules are reporting of income, and based on her income tax, it appeared that she did not do so by a probable cause standard. I think.
yeah, I don't think I need to hear any more. I think there's clearly enough here for a factual issue, factual determination. Defendant is bound over on count 1. Again, I'll just state for the record, the prosecutor moved to dismiss count 2. Count 2 was dismissed. Court finds probable cause to believe the crime of welfare fraud over $500 was committed and that the defendant probably committed the crime. I'm gonna go ahead and bind the defendant over. If you'll just wait with all the Christmas holidays, I need to figure out what date this AOI is gonna be.
Thank you.
Can you, jeez. I've been a little. I just set one yesterday for January the 8th. We've got a little luncheon going on down there.
Sure.
I'm gonna make it January the 8th at 9. Ms. Barkovic, I'm gonna ask you to go down there and just double check, and you too, Mr. Kessel. But I'm gonna put it for January the 8th at 9, and I wish both of you a Merry Christmas, Happy Holidays. And enjoy your
This
time off. I
courtroom
hope you
hearing
get a few
wasn't
days.
about whether the defendant received government assistance. That part wasn't in dispute. The real question was whether she intentionally failed to report income in order to receive thousands of dollars in benefits she wasn't entitled to. The prosecution called a state investigator to explain how the benefit system works. According to the witness, every applicant is informed that they must report all sources of income, including employment, self-employment, disability payments, and other earnings. The investigator testified that applicants are given information explaining their responsibilities before signing the paperwork. Prosecutors then introduced tax records showing that the defendant reported more than $66,000 in income on her federal tax return, while allegedly failing to report that income to the state benefits program. According to the investigation, she received more than $13,000 in benefits that she would not have qualified for if the income had been properly disclosed. But the defense wasn't convinced the case was that simple. During cross-examination, defense counsel questioned whether the investigator actually knew if the defendant understood the complicated rules governing what counted as income. The investigator admitted he had no personal knowledge that she had actually read or fully understood the lengthy policy manuals provided by the department. The defense argued that the application itself did not clearly define income and pointed out that government policy manuals contain hundreds of pages of technical explanations. According to the defense, misunderstanding those rules is very different from intentionally committing fraud. The defense also argued that prosecutors had not shown the defendant knowingly made false statements. They claimed there was no clear evidence that she personally received the money in question or intentionally tried to deceive the government. Instead, they urged the judge to dismiss the welfare fraud charge entirely because the prosecution had failed to prove fraudulent intent. After listening to both sides, the judge delivered his decision. He explained that while the defense had raised important questions, those issues were ultimately for a jury to decide. At this stage, the court only needed to determine whether enough evidence existed to move the case forward. The judge found there was probably